May I please the Lordship? My Lord, I have a prayer in item 41, my Lord. This is a hearing matter, my Lord. This matter may kindly be upgraded and may be taken at 2 p.m., my Lord.
We don't know because we have to rise and my esteemed brother has a lot of matters today.
This petitioner, my Lord, otherwise, my Lord, he is the grandson of, my Lord, the Deputy Speaker of Assam, my Lord.
Oh, achha.
Assembly, my Lord.
Better mention
That
earlier.
matter, my Lord.
We'll try to, otherwise we'll adjust.
At 2 p.m., my Lord, if possible, if time permits to me.
If time permits.
Yes, please. I'm deeply obliged.
May I please the Lordships? Item number 7, I'm paying for item number 7, Lordship. Can the matter may be fixed up on Monday, Lordship? Actually, my senior, Mr. S.C. Vishwas, had to rush to family court because of an urgent matter, and it might take some time. That's why I'm paying for the matter may be fixed on
The
Monday.
prayer made by Ram Council for the petitioner, Master of the Judge today, list to it on Monday. Okay. 24th August.
Obviously.
Lord, when praying in respect of items 33 and 34, they are both husband and wife, and these are ex parte orders, Lordship. They are not enjoying any interim protection, Lordship. If, Lordship, the matters don't reach, would it be possible to take it up as the last item, please?
Okay, we'll try to.
Much obliged.
Please, Your Lordship. Lordship, item number 35, admission. On the last 4 occasions, it was left over, Your Lordship. Lordship, if the
We'll
court.
try to. Okay, today we can't assure.
May I please, Your Lordship? Item number 28, admission. My senior is out of station today, Lordship. Case may be adjourned for the day, Lordship. If possible, Lordship, case may be fixed after 2 weeks, Lordship. If possible.
28. Looks as a representative on the prayer made by Ram Council for the petitioner, list to 2 weeks.
28. Okay.
May I please the Lordship? I beg to mention item number 23, Lordship. Due to some difficulties, can the matter may possible for the day, Lordship?
23 is 2021 matter, you will have to wait. Till 2021 matters, we are not adjourning at the motion stage, at the mention stage. We do the prayer when the matter is called.
Item 1 for motion.
Made to the Lord. Made the Lordship, I'm praying for an adjournment in this matter, my Lord. On behalf of my senior, my Lord, he is not fully recovered, my Lord. So I'm praying 2 weeks time, maybe, my Lord.
Okay, both sides are represented on the prayer made by Ram Council for the petitioner. List. It's a motion matter, we have a date after 2 weeks.
Highly obliged, my Lord.
Item 2 for motion.
Able Lordship, my Lord. My Lord, in order case 67, my Lord. This case, my Lord, order first notice, my Lord, Elser Court and Ultimate Grand. Case 67 open. And here this case, my Lord, I have gone through the, my Lord, the opinion, my Lord. The only, my Lord, the proceeding took some time, my Lord, due to the COVID conditions, my Lord. On that down, the as per provisions, my Lord, the matter should be completed within the 60 days, my Lord. So on that down, the case was, my Lord, declared as a motion, my Lord. And what this case, my Lord, the all other relevant documents, all the documents, my Lord, the linkage, my Lord, with this father, parents are related, my Lord, or my Lord, 66 totally 70, my Lord, then my Lord, 89, next, my Lord, 2008, 2011, 2019. All this voter list include the, when the petitioner in eligible for voter list include with his parents, my Lord. And mother also deposed before this honorable report. I'll give you 2, my Lord. And on the ground, my Lord, the page, my Lord, see the last 4 pages, the only duration, my lord. Only duration, and that beyond, my lord, zero. And the duration here, the, my lord, the case was that time with the pandemic, my lord. And it take two times, my lord. And here the order also reflected that part, my lord. So, my lord, at this stage, my notice was not issued yet, my lord. And ultimately, it may go and the next case for admission hearing at the station, my lord. If my father's name, Uncle Mojit, my lord, and extra one, give it to, 70.
Mr. Pang, right, that was COVID period.
My lord.
That was peak COVID period.
Yes, sir.
He missed out the COVID period, the extension was time of was till 28/2. He missed out one date, that is 25/3/2022.
Expert.
The travel in the page 70 says that first lockdown periods were taken account of.
Hmm.
The second lockdown period was not taken into account.
Let's
Just see that. Page 70. He made a mistake, he delayed one day that was not COVID period.
Yes.
Excuse for the. Going to be secret. Mr. Chalil and counsel for the petitioner and so for the respondents. Next one. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated 12/4/2022 passed by so-and-so in case number so-and-so corresponding to FT case number so-and-so by which he was declared to be a foreigner of post 25/3/1971. Next paragraph. Next paragraph. In brief, the case of the petitioner is that notice was served on him in a substituted manner. But from 18/3/2019 till 26/7/2019, the petitioner was absent without steps. So thereafter, he entered appearance on 30/7/2019 and filed his written statement on 31/8/2019. And thereafter, in support of his defense, the petitioner had submitted his affidavit on evidence on affidavit as OPW-1 and of Jaigun, Jaigun, Nessa, his projected mother as OPW-2. Full stop. Along with his evidence on affidavit, the petitioner had exhibited 6 documents. Full stop. Full stop. The petitioner was cross-examined and discharged. Though the case was fixed for the cross-examination of DW2 on 24/3/2020 by order passed on 18/2/2020, but since then there was no representation on behalf of the petitioner, and the DW2 also did not turn up for a cross-examination. Full stop. In the meantime, COVID pandemic period had set in. And as there was no representation from the petitioner till 25/2/2022, the learned tribunal by an order dated 25/2/2022, fixed the matter for opinion on 12/4/2022, and accordingly on 12/4/2022, the impugned opinion was passed. Next one. The learned technical for the border and FT matters has opposed the prayer for any interference with the impugned opinion on the ground that the petitioner had defaulted in appearance and did not examine DW2. Sorry, and did not present DW2 for cross-examination. Next one. Whether as it may, the for the purpose of judicial proceedings, comma, the Supreme Court of India in the case of colon recognizes for extension of limitation within bracket 2022 bracket plus 3 SCC 117 comma by an order dated 10/1/2022 declared that the period between 15/3/2020 and 28/2/2022 shall be excluded in computing periods of limitation. Full stop. Though question of limitation does not arise in the present application, but the fact remains that during that period, the COVID pandemic period had prevailed in the country. Full stop. It is in the said context that it would be appropriate to mention that in the impugned opinion, comma, the learned tribunal took into consideration the first lockdown period between March 2020 to October 2020, but the second period of lockdown no, the first lockdown period was March 2020 to October 2020, and the second lockdown period was January 2021 to October 2021. Stop. But the said learned tribunal had recorded in the impugned opinion that the first and second lockdown due to COVID-19 has not been taken into consideration while passing the order. Full stop. Next, accordingly, the court is of the constitutional opinion that if the COVID pandemic period is excluded, the petitioner had defaulted in appearing and taking steps on 25/3/2022, which was the date previous to the passing of the impugned opinion. Accordingly, the court in exercise of power in the Article 227, 2026 of the Constitution of India, is of the view that the petitioner deserves one opportunity to present his projected mother, Jaigun Nessa, the OPW2 for facing cross-examination. And on the said date or on such other date as may be fixed by the learned tribunal, the petitioner would ensure that the hearing on his behalf is conducted by his learned counsel without any adjournment. Next, in order to facilitate the cross-examination of OPW2 and the argument by his learned counsel, the impugned opinion dated solely on that ground. No? Without finding any fault in the opinion of the learned tribunal. Next paragraph. The petitioner, was duly represented, the petitioner, namely Muhammad Jalaluddin, or Khuli Jalaluddin, J-A-L-L, next word Uddin. Was duly represented by his learned counsel, is directed to appear before the learned member from a foreigner's tribunal within bracket third, bracket close Nagaon, on 28, on or before the, on or before 28, 9/2026 without default. And by producing the certified copy of this order as well as OPW2 for a cross-examination, await for further directions that may be passed by the said learned tribunal. There, after to say that it is clarified that the court has not and had not examined the merit of the matter. Then we asked to say that it is further provided that on the date of appearance of the petitioner, he shall be ready and willing to furnish bail to take bail of such sum as may be deemed fit and appropriate by the learned tribunal. It is provided that the bail so granted by the learned tribunal shall be valid for a period of 30 days from the date of the opinion that may be passed by the said learned tribunal. Next paragraph. The registry shall send the return back the tribunal's records expeditiously. Next paragraph. Requisition stands allowed to the extent as indicated above. So there shall be no orders to cost.
Hello.
Yes, item 3 and 4.
My please lordship. In this case, I was permitted to submit, but inadvertently I served it today only. Secretary has come, he is outside, but we cannot communicate with others.
I did not get it. Please say again.
There was lordship direction. Notice was issued to the bar
Yes.
council of Assam.
Yes, yes.
And I was also permitted to serve a copy of this.
Yes.
But I did not follow the last part of this order earlier, Lordship, but today I have served it. And secretary is outside the courtroom, but nobody could be.
Okay, tell him we'll take it up next week.
Next week.
It will. Both sides are represented. Next, Mr. S.D. Prakash, on the counsel for the petitioner has submitted that he had missed out paragraph 4 of the order dated 5/8/2026, and only today the copy of the order dated 5/8/2026 could be served on the Secretary of the Bar Council of Assam, Nagaland, etc. Full stop. As insufficient time was available to the Bar Council of Assam, Nagaland, etc. The matter is adjourned today. List on, give a date after 10 days. As per the learned counsel for the petitioner shall inform the Secretary of the Bar Council of Assam, Nagaland, etc. about the refixing of the date of the proceeding of this case on. There will be separate orders or common order here,
One order.
or separate orders,
Separate order.
both the cases. Mr. Fine, this is that matter where we issued a direction for the Bar Council to have a mandatory training for the lawyers in practice.
Yes. That's.
That is necessary, but not very much necessary.
Huh?
That is very much necessary for us.
Continuing education is a part of our life.
Yes, yes, yes. Once after LLB is completed, there is no in fact training, any type of training for the better.
Let us see how it is reacted to.
We have to learn from the code from the LLB to the practice.
So that's the most important learning on the or
Whatever we learn,
brushing up is also very important.
whatever we learn in code, that's possible.
Both of us learned in court only.
No, but that is true.
However, Madam, there must be some induction program there in every class. But what happens, my lord, this is, we have seen, when we conduct some kinds of programs in bar, the attendance is very less.
Yes, it is.
Yes. Attendance is very less.
I had gone for interaction on the Evidence Act for the Lawyers Association in Gauhati.
Yes.
And there were hardly 20 advocates. Out of 20 advocates, 10 I knew. They perhaps came out of politeness. There were only 20 people in the auditorium to hear my deliberation on Evidence Act.
The issue, in fact, but I'm sorry to say, my lord, when I was the secretary here in Bar, I tried to do lots. But what happens, my lord, even in our references, we used to remain only 5 to 8 people in the references. In Bar, my colleague is, my lord, no more. In the name of my colleague, my lord, if I ask to at least attend for 10 minutes, there is no time for the lawyers. We have no time to, in fact, that is the issue, madam. We have no time at all. The lawyers, this is the problem here. Everybody is running here and there, here and there. Nobody has time.
That is the problem.
Yeah, right.
Item 6 for motion.
Okay, right. Okay.
Make the lordship. Lordship, this is the case which after remanded by this honorable court, this is the findings by the tribunal bench. Earlier, remanded me lot, this honorable court observation at page 112 me lot, paragraph 20 and 21. 25.
No, where is the impugn of opinion?
Yes, my lord, page 118 my lord. And discussion my lord. Page 132. Paragraph 15 on.
No, impugn opinion is where?
132, my lord, paragraph 15 or not, whole paragraph 15. No, 15, 118. Full paper, my lord. 118.
118.
Yeah, 118, my lord. And 12/5 what, sir, order, 12/5/2023. Let the record come.
Right. Mr. P. K. Degal and counsel for the petitioner and so and so for the respondents. Opinion is at page 118, dated 12/5/2026, passed by so and so in case number so and so, TS case number so and so, by which the petitioner was declared to be a foreigner post 25 in 1971. Notice returnable in 4 weeks, extra copies within 2 days. Call for the record from the following email address of the learned tribunal. Next, prayer for bail is opposed by the learned standing counsel for the border and FT matters. Assuming the prosecution, 10 days time to take bail out of this 5,000 to the satisfaction of Superintendent of Police Border, South Samara. Mankachar. Let's start for 4 weeks on the seat of tribal sports.
Lots of blood.
Supplementary item 42.
Yes,
I may be taken up, page 5, para 6.
amen. Page 5.
Yeah, para 6. In the last occasion, your lordship will recall the respondents, they have produced the instruction by the Commissioner of Police stating.
Okay, you can allow this, Mr. Iyer?
Yes, my lord, if it is clarified, my lord, we have no objection, only because he has not, my lord.
But Mr. D. K. Agarwal will counsel for the applicant. This will be in IA. Your call? Your name? K. Kalita on behalf of Mr. K. K. Parashar, CGC. For respondent numbers 1 and 2. And J. Pang, Leonard, standing counsel for the Home and Political B Department, representing respondent number 3. Next one. By filing this interlocutory application from the applicant 6 incorporating the name inverted commas ZD Michelle alias Maureen invoke comma close as an alias of the applicant, comma, who is the petitioner in the connected writ petition. Next one, it is submitted that though the name of the petitioner is, sorry, applicant is para 5, Maureen Cinnamon Vincent, alias Maureen Cinnamon Vincent, comma, but the applicant was prosecuted as Z.D. Michelle alias Maureen in the proceedings of PRC number 456 of 2024, arising out of Azara PS case number 155 of 2023, where she was convicted and sentenced on 4/4/2025 by the learned Subdivisional Judicial Magistrate within bracket S bracket close -1 Kamrup Metro, Gauhati. Accordingly, the learned counsel for the applicant has submitted that unless the name Z.D. Michelle alias Maureen is incorporated as an alias, comma, the applicant may not be ultimately released by the detaining authority, by the concerned authorities. Next paragraph. The learned counsel representing respondent numbers 1 and 2, as well as the respondent 3, have no objection to the prayer made. Accordingly, comma, the application stands allowed by permitting the name of Z.D. Michelle alias Maureen, sorry, Z.D. Michelle alias Maureen to be an alias to the name of the applicant in the writ petition, connected writ petition. Next for this. This application stands allowed and disposed of. In the writ petition, you say, so and so, in view of the order passed today in IS Civil 2841 of 2026, the petitioner shall, allowing incorporating the name of so and so as an alias, the name of the petitioner, the learned counsel for the petitioner shall file the amended cause title by handing it over to the AOJ FT section, who shall incorporate the same in the writ petition and also update the CI system. And thereafter, the matter be immediately listed before the court.
If date may be given, it will come. Grateful.
Item 8 for implement of party.
Oh. Page 12, notice was issued.
Is 12 kindly see mail IA 1067.
Yes.
Notice 7/1/2026, your lordship has issued a notice in this case
Yes.
on 7/1/2026 at page 12. Whereafter my lord, the incumbent who was there earlier, he was transferred. So we filed an application for impeachment of new incumbent.
This is the application.
So this is the present application 1067. 1067 is the application.
Page 8 will be there.
Please see page 8 is the prayer in this IA
You want to
application.
impede whom?
I'm sorry, my lord.
You want to impede whom?
Present commissioner.
Present commissioner, ma'am.
Commissioner, who is holding the post at present.
Where do we get the name?
Your lordship will get the name.
Time we have not made.
No,
So, see,
no.
at the time of filing. I'm sure if the transfer हो जाए, the by post हमें यदि party को, that would be better, because again if it is transferred.
Again, if it is transferred, then what will happen?
Pardon me?
His name no
Diganta Bora is the name.
Diganta Bora is the name, but there has to be name.
No, but it has to be by name. It can't
I
be by
know.
office.
So name
My name could.
We'll do it, my lord.
You can withdraw this as final fresh one.
Yes, sir, we'll do it. Name नहीं भविष्य में नाम लोगों ने वो कौन थे?
You say, Mr. D. Das, the senior counsel, assisted by Mr. S. Das, the counsel for the applicant, submits that due to some due to a technical error in the application, he seeks to withdraw the petition with liberty to file again. The prayer is allowed, the matter stands dismissed from the law with liberty as taken.
Yes.
Mr. Das. Mr. Das. In the contempt matters, we are moving something which is on a conceptual stage. I don't know. In contempt matters, we are moving proposition which is still in the what you call boardroom stage. We have to thoroughly discuss it. In contempt matters, we are contemplating to have something which is akin to Order 6/14A, by virtue of which party can be impeded merely by filing a memo without the rigors of filing an interlocutory application.
Yes.
So we see how it goes through, but it's in a conceptual stage right now.
All the time we have to change it. This is the.
We're just putting an idea.
Yes, it's not bad idea. It's
It depends how the House takes it,
yes.
how the
But with great
bar would
respect,
react.
with great respect, my lord. I have also put in this situation for long 40 years. Some may this way that one has to be very strict in a content. I may be on the other side. That's a different stake. We have
No,
seen.
that
my
is on merit, but
My
we are
lord.
only on the
No,
issue of
that's a
impeding.
different thing, but on merit also I am saying, no, it's a very good, if your lordship can does it, it will be very good. So all the time, your lordship, right, we have to come up with an application for changing the name, implement.
We are
But
seeing
in
it's just in a boardroom stage. We don't know how it comes, how it eventually comes.
Yeah.
Yeah, just, I thought you'd share with you.
No, I am agree. It will be very nice, my lord, if it is done. I could not sleep also. Yesterday in my chamber, it is the water is up to my knee level.
Oh.
My
Sorry.
mother has to be shifted upstairs. 3 hours continuous rain, you can't think of. This is my worst, I will tell, in my lifetime. 40 years I have not seen. I have not seen.
Really bad, getting worse. Getting worse.
And nowadays you will not find this area there will be rain and other parts it will be dry. I called few of my friends and I said that what has happened in here, because no, it's fine, there is no water.
I'm
Logging.
informed today morning when I came here, I've been informed that Gandhi Basti is inundated, Lime Road is inundated.
Yes.
So I was requested by someone not to dismiss any matter because of
Right.
the artificial flood.
I don't know how it will be solved. I don't know.
That's right.
Mr. Goswami, P.K. Goswami was sharing with me. He's saying that until and until the drains, we have seen earlier, Gauhati has seen, the GMC truck used to come and they used to, because there are a lot of silt.
So that's what do you call, I have a different view altogether. You see, you forget about the civic drains. In the High Court bar toilets, when the toilets are cleaned, the what do you call, the liquor bottles come out of that also.
That's true. 100%. That's true.
So what to do? This is the state of affairs with the literate class. The drains, when they were uncovered and the sludges are taken out,
Well, drains nowadays, the
50% of the sludge is that what do you call, liquor bottles.
no, last 2
Plastic
years,
bottles.
I have not seen any drains now. They are trying. The GMC is doing any work so far as this concerned. They are not doing anything.
You join, I think there's a PIL going on. You
I
can
think
join that.
they have started initiating one PI.
Somebody can join. Good.
Yes, I have been told. That's taken up. Deeply up.
Upgrade item 32.
This matter is looking after the dinner now. Can it be Tuesday for discussion? We have file affidavit, he has filed reply also, Lordship. Pleadings are completed. Oh, yes, Lordship. Tuesday.
Bora Bora, learned government advocate, pays for a short adjournment. Mr. There is allowed. Matter stands adjourned today. List on 29. Sorry, 25, 8, 2020. Oh, not on 25, it will be 27. We have a special bench for that.
Diploma.
Upgrade item 37.
Yes, what has happened?
I have received some instruction, but we have the copy yesterday only.
Why?
Milord, I was under some ailment. I received instruction from our 2 days
Habeas
without.
corpus, In habeas corpus, you don't
My
have
lord.
urgency.
My lord,
You can have sent it by somebody, you don't have to
Yes.
physically work.
My lord, but I could not come to the court. My
But
mother
you have sent by someone, you
My-
see, when we say that you give him a soft copy and hard
My-
copy, you don't know the problem they have in
My-
communicating.
Then, मतलब day before yesterday. I received him. He is already my lord. End of our.
Handed over.
Yes, yes. Certified copy I have sent, so,
You see,
but it was.
you see, from the, so far as bench is concerned, we are thankful to the, all the learned government advocates, including the CGC, what do you call, the government advocates and the, even for the ECI, Mr. Ali and all. Because their response is so fast when we make a request, they understand the urgency and they react so fast.
Yeah.
There are times I'm surprised that it is with that effort they could have done us the favor and getting all the instructions. They've not, they've hardly failed us.
I'm really sorry for that, you know. Even my assistant also, he is in the hospital, you know. So unfortunately, that happened, you know, that I could not send the copy. You know. Otherwise, I would have been very prompt and serious in it. Because your lordship has given enough, you know,
Okay, then this matter closed.
yes. You know, my only prayer is that, you know, earlier occasion also, that I was put to, you know, detention on several times, you know. If I'm not having any other disability, you know,
No, you see, you will have to think of some other modality.
my,
You'll have to think
my,
to stand in the elections, coming elections, become an MP, change the law and permit us to take up domestic violence cases, domestic dispute cases in the High Court.
my lord,
If
my
I can amend the,
subject to your lordship's approval, my lord, my limited prayer would be, my lord, that unless, my lord, I have no other disability, in case that the rehabilitation center or the police is called on, my lord, without the, my lord, opinion of the consent of the
no, every time
parents,
you'll have to do it. If it, you see, if at my home,
my lord,
even if my family members accuse me that I am not in the appropriate state of mind,
my lord.
would the police stop even from taking me to a for a medical checkup?
That is, that is, because the parents are not consulted, my lord, then at least that, without the consulting the petitioner, my lord, that he cannot be taken into. That
Can't be, can't be. What happens, you see, we have got cases,
my,
we have got cases, you can't generalize things. What happens if the husband starts beating up a wife at the home? The neighbors make a complaint that the husband is unruly. And we pass an order that unless you take consent of the mother, you can't take him into custody. Can that happen?
of course, that cannot be, my
Then?
lord, that cannot be. But the,
Then there can't be a blanket order.
My-
It amounts to something like a anticipatory bail.
my lord.
We can't do that.
But of course, my apprehension is that, you know, if she had not done it earlier, and that, you know, if I would have, you know, assaulted her, there is no complaint to that effect, even, you know, I entered.
Mr. Ali, no point
My,
in prolonging this discussion.
my,
If you want this,
My-
you'll have to go to civil court, get an injunction.
my,
That can't be done in a writ court.
I'll comment.
You go to a civil court, you
My-
get an order of injunction
My-
that the wife will not make a complaint against the husband before
My-
the police.
I'll do my,
Do that.
my. As for your lordship's order, it is just taken Mirza CSC.
And do. Mr. A.R.L. and counsel for the petitioner is present. He is present and heard. Full stop. Next, Mr. P. Sharma, an additional senior government advocate, has produced written instructions dated 20 August 2026, issued by the officer in charge of Parashbari Police Station, informing that pursuant to order dated 17/8/2026,
Order the file.
the petitioner appeared before him and produced a certified copy of the order of this court dated 17/8/2026, and accordingly, team visited the
Case number
The Rehabilitation Center
9.
under the name of Nisha Mukta Kendra at Lashit Nagar, Mirza, and the son of the petitioner, namely, Jayanta Das, was taken from there to the Mirza CHC for medical examination, and post-medical examination, he has handed over to the petitioner. It is reported that the said actions are duly reflected in the Palasbari Police Station GD entry numbers 8, 9, and 10 dated 19/8/2026. Next paragraph. The Learned Counsel for the petitioner does not dispute the correctness of the said report. Next paragraph. Accordingly, on satisfaction, this petition stands closed. Next paragraph, we record our appreciation towards the officer in charge of Palasbari Police Station for prompt action taken.
I'm obliged.
The next paragraph, the Learned Additional Senior Government Advocate shall communicate the order to the Palasbari Police Station, download copy to the Palasbari Police Station. We have appreciated his work.
I am obliged.
Upgraded item 38.
This is delay application. So my review petition may be taken up at page 73. Yes, my lord.
Condone.
If my lords may kindly see to page 73 of my review petition.
Order.
We were once
Order 3625.
we were before Honorable Supreme Court, and there was an order passed on 27/1/2026. Can we read the order?
Common practice, my lord.
Otherwise, what is the main order is an ex parte order. I've also been in detention for 2 years. I have explained the entire delay, man. Welcome.
Once you overcome the question of delay, then we go to the merit.
Yes, sir. So the delay, there's only 144. The order was passed by the Honorable Supreme Court on 27/1/2026. We filed this review on 26/2026.
5 months.
Yeah, so that is 144 days. So first 2 minutes that I am in detention. I am in detention for last 2 years. Secondly, what has happened, is that, we have to obtain wakalatnama, this entire formalities that we have to do. So that is the difficulty. It comes from a very poor background, and you lordship will recall that with all fairness, will recall that even I had a terrible accident. And that point of some delay was also condemned from my part. And otherwise, we have a very good case on merits. It's an ex parte case in which, at the time of the order was passed, the state was also not there. I have the entire order sheet with me, and that was been when making that judgment that was overlooked. And I have suffered enough, for 2 years, I have been in detention. At the time of today also.
When the Supreme Court says you filed the review, that doesn't mean 144 days.
Yes, sir. We understand, there is a difficulty, Otherwise, I'm in detention also. That is also has to consider. If my relatives they don't do, why should I be faulted? Because I am in detention. In some liberty, some mercy, Otherwise, the main case is a FT ex parte case. I'm invoking mercy jurisdiction now at the end. Para 5, I have explained the reasons of delay also. In my IA. I will.
Only the.
Is your submission?
Lordship may. Submission is that Lordship may. If Lordship thinks fit, notice may be issued. Otherwise, Lordship, my humble submission is that Lordship, before arrest, this petitioner never bothered about the case, Lordship. He very much aware about the proceeding, Lordship, and that things were not discussed in the submitted days, Lordship. After, immediately after arrest, he approached before this honorable court. So he very much aware about the case, Lordship, and except notice file WS, Lordship. But after that, he stopped to appear before the tribunal, Lordship, and immediately after arrest, Lordship, he approached before this honorable court. His petition was not entertained by Supreme Court also, Lordship. So, yes, Lordship, he was dismissed. Yes, Lordship. After hearing, Lordship, it was withdrawn, Lordship. Which implies that Supreme Court never entertained his petition, Lordship.
when you present a writ petition or a review petition, you'll have to, first elementary thing is that you have to draft it, then have it typed, have it presented before the court. Before presentation, there's one important thing. You must go through it, what is being presented. You make the act of not revising what you have written. Clients will cut a very sorry figure. Come to page 15 of your review petition. We are not saying anything, just read even by yourself.
Sorry, Manoj, page 2.
Para 21, just read for yourself. Don't have to read, say loudly. You have not found anything.
Is it the word writ petition?
Para 21, you have read and not found anything. Then you can't say anything. You don't say anything.
So it should be a review petition.
We don't know.
That's
We have not seen review petition. We are just concentrating on the condemnation application. That's why we said that it should revise whatever you write.
May I respond to my senior? May I respond to what my seniors arguing? On the delay part, and then I will come on the management. On the delay part is this that on 27/1/2026, the first and foremost is that it was submitted that we were not entertained by the Honorable Supreme Court. We were not entertained by the Honorable Supreme Court. Whereas that is untrue, my lords. We cannot decide that what is going on my lord's mind at that point of time. Because after that, Savitri days comes and Savitri days is squarely covered by Savitri Day. I am the third category for first my lords. My lords, and the second and the third, my lords, that one of the cardinal principles in the whether when the delay has to be condemned, whether I am enjoying the fruits of the delay. Here, my lords, I am in detention. So it's not that I am benefiting. Rather, it's my lords, it's by filing this delay application, it is I am suffering. Whereas that is why briefly which covers thus broad submissions on the delay part. And the second, the delay is only of 144 days from the order of the Honorable Supreme Court. Now, my lords, come on the merits question. I'm just bringing the three grounds I have. Whereas the foremost grounds is that I have the order sheet, my lords. If I may, please, I have only one copy of the order sheet. I have phlegmaed it. I have phlegmaed it, the blue, the order dated 5/5/2021. That is the only date in which the learned tribunal member records the presence of the AGP, the government pleader. Subsequently, there is no record of government pleader. Now, if on the date of passing of an ex parte, government pleader doesn't come, then what happens? The order has to be passed in terms of order 9, rule 3. And the suit has to be dismissed by the CPC. So in this case, it's not that only I don't appear, it's the reference authority also doesn't appear. So this was overlooked, my lords. This was also the record was there before, my lords. There is the second argument is it is not their case even that I have that I don't have a case. In fact, the notice that they have suffered, they have issued to me, it is a notice of 66 to 71. This is another one that I am placing before you, lords. It is an original document. So it is not their case that I am a prima facie, I am a foreigner. When the state thinks that I have a strong case. So let's see. And this was also overlooked. So and third case is this is an ex parte case, ex parte and post Savitri Day, no person may examine from the state, I also deserve the protection of Article 14 and 21, as Honorable Supreme Court has said in Savitri Day. So that is my brief submission. Just 3 points I have stand before you on the ground of review. And once you consider on all of it, I am the one who's suffering, my lords. Because I am in detention for last 2 years. I have nothing to gain, my lords. So, otherwise, my lords, see, is that there's a mercy petition also. That's all. I am only seeking remand back so that contested fair and opportunity is given to me and I present my case. I am not seeking quashing or anything else. So that is also the ball is still at their hands. Otherwise, had the tribunal passed an order under uh, Order 9, Rule 3, it would have been a dismissal. They would have had to file a re-suit or an appeal.
Heard Mr. D.K. Agarwal, counsel for the applicant and Mr. So for the respondents. Next one. The heard both sides on this, in respect of this application. List on 25/8/2026 for delivery of orders. You will give him back, please.
কি ইনষ্ট্ৰাকশ্যন ল'ব লাগে আপুনি? মই কি ইনষ্ট্ৰাকশ্যন ল'ব লাগে তাকে?
কাৰণ এফিডেভিট দিম বুলি ক'লে, এফিডেভিট দিম বুলি ক'লে। প্ৰথম দিনাখনে ইনষ্ট্ৰাকশ্যন ল'ব গৈছিলো মানে মোচনত। মানে মোৰ ৰেকৰ্ডত পোৱা নাই সেইকাৰণে আপোনাক সুধিব।
কিন্তু তেনেকে ইমান মাতিলে মানে কি হয় কাইলৈ আকৌ মোৰ ওচৰত কিন্তু চাৰে ঘৰতহে লৈ যাব। শ্লিপখন লগাই দিম। তাতে মই এছপিৰ নামটো লিখিছে।
Upgraded item 33.
Thank you, Your Lordship. My senior is leading the case. He is engaged in another court. Kindly pass it over for the time being.
I mean, it goes for the day because we can't accommodate. Because we'll be rising at 1 o'clock. Next call with you.
Thank you.
It may not be called today.
Upgraded item 35.
Big thing, Your Lordship.
You are supposed to file an affidavit, you have not filed.
Lordship, my department of.
Yes, you are supposed to file.
Lordship, 1 week time may be allowed. Lord.
Mr. Fine made the submissions on the last date, 11/8.
Some academic and Lordship stand for bidding.
So just find it out whether you are filing it or not filing it, because the petitioner here, she's in detention. She or he, I don't know, she's in detention. That's why the urgency.
Actually, on the very first occasion also, while issuing notice, the other party was asked to issue, take instructions.
Lordship may take it next Friday, Lordship.
But don't expel her.
No, Lordship. I think Lordship already, that already was there,
No.
Lordship.
That's not there. He doesn't have the protection.
Lordship, this is for,
Then-
not for the citizenships, Lordship.
Hmm?
This case is not for the citizenship, Your Lordship. This is 2019 judgment of Supreme Court. It is found in the annexure 5, page number 36. Where it is clearly said that whomsoever is awaiting their deportation and have completed more than 3 years,
He's in detention.
yes, he is in detention.
That's why you see.
They should be released. Page number 36, Your Lordships. And is more than almost 3 months is in illegal detention, Your Lordships.
Hmm?
More than 3 months he has been illegally detained in detention center.
Yes. Has to be. A foreigner who has been detected cannot be allowed to roam everywhere. This person. How much time?
Lordship, one week, Lordship.
But till then, don't expel her. We are putting that in the order.
Lordship.
Mr. A. Sahria.
Yes, sir.
Heard Mr. A. Sahria and counsel for the petitioner. Next, Mr. G. Sharma, and you say all sides are represented, all the respondents are represented. First of Mr. J. Pang, and it's standing counsel for the Home Department, for the border and FT matters. Place for further 1 week's time to file an affidavit in the matter. Next, paragraph. As the petitioner projects that he has been taken into custody and is presently in the transit camp, Matia, Guarpara, since Mm-hmm. 27/5/2025, or the court is inclined to provide that till the next date of listing, the petitioner, namely Srimati Hamida Begum, shall not be expelled from the country without order of the court. The petitioner is shall produce the certified copy of the order before the Superintendent Transit Camp, Matia, Guarpara, to bring the order to the notice of the said authority. Next paragraph, list on, give a date after 7 days.
Obliged, Lord.
Upgraded item 33.
Please, your Lordship. Lordship, it is an ex parte case, Lordship. In this case, Lordship, the item 34, she is the 34, the petitioner is the wife of the petitioner in item 33. In respect of item number 34, Lordship, the notice was not at all served to the petitioner, and saying that the addressee could not be found. In item number 33, Lordship, the petitioner's the notice that page number 25.
Two matters together. You first complete one and then go to
Lordship.
another.
I'm just referring because in item 34, they say at the same address, they could not find anyone.
Let us see one by one.
Lordship, item 33, The process server's report is at page number 27, Lordship. In this case, it was served at the house of the son of the petitioner, but both of them live separately. I filed an additional affidavit also bringing on record the present voters list, which reflect that they live separately. Page number 26, Lordship, is the type one. Lordship.
The, inquired with. Total residence. Here.
And Lordship will kindly see the address is given as Bagheshwar in the notice. My documents reflect that my address is Fohuratoli. Although this and one aspect, Lordship, it has to be handed to me in person, and only if I'm not there at the house, then it can be given to the an adult member of the family. Nowhere is it recorded that I was not present at the house, because of which it was given to my son. I have annexed at page number 28 a certificate by the Vice President of the jurisdictional Jao Panchayat also, who acknowledged the fact that I live separately from my son at a distance of about 3.5 kilometers away. And Lordship, I've perused the record also. No, Lordship. In a different house. That one certificate is there at page 28, and I filed an additional affidavit bringing on record the voters list of 2025 and 2026.
That means the professor gave the notice at a different address.
At the address where my son resides, he is the eldest son, he resides separately. My son never informed him.
Where's the separate voters list?
Lordship, my additional affidavit at page number 47. Forty-seven is 2025 voters list. His house number is 300. My house number is 372. My son's house number is 513, Lord. Sairuddin Ahmed, he is the one who had received that notice.
Yours is 72.
Yes, Lordship. Similarly, the 2026 voters list is at page number 50. Lordship, I have also seen the trial court record. In fact, on a previous date, the process server said that nobody could be found at that address. The order sheet recorded that. The notice was reissued at the same address again.
So he may have met the person. He may have met the person. And he went there, he could not find.
One Lordship, my name is Atalab Hussain. In all my documents, it is recorded as such. Notice says Altaf Hussain. And
So he found, next time he
On the-
found his son.
my son,
And gave it.
somebody,
But
and gave
your
it to the
contention
son
is
at
that
his house.
it's a different house.
Lordship. My son actually, he used to, at that point in time, he used to work outside the state. He had come for 2 to 3 days. During that time, it was given to him. For a few days, he had come to his home. And the vice president of the Gau Panchayat was also issued a certificate in this. Lordship, the coroner's tribunal order also reflects that it should be delivered in person. And similarly, the full bench of this honorable court in the case of Muslim Mandal has also recognized this aspect. Even the Guwahati High Court civil court rules, they also say that when it can be served on an adult member of the family.
Which certificate you are relying?
Lordship, page number 28. 29 is the typed copy, handwritten copy, original.
Petitioner and so for the respondents. Next, by filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the party opinion dated it's at page 17. It's party opinion dated so and so, passed by so and so. There are two references. Case number so and so, FT case number so and so, reference case number so and so, by which was declared to be a foreigner post 25 to 1971 stream. Next paragraph. The interference with the impugned opinion, ex parte opinion, is opposed by the Union Standing Council for the Water and Electricity Matters. Next paragraph. Pursuant to the order passed earlier, the records of the tribunal is received. On a perusal of the tribunal's records. It appears that the process server, on not finding the petitioner, had inquired with the local residents and the block level officer, within bracket BLO for short. And went to the house of the petitioner and explained all about the notice to his son and handed over to him the second copy of the notice. And the service report was returned to the learned tribunal. Accordingly, the learned tribunal had passed the ex parte interim opinion dated 26/4/2022. Next para. The learned counsel for the petitioner has referred to the certificate dated 2/4/2026 issued by the Vice President of number 13, Bazana, Bazana Thar, Bazana Pathar, Gaon Panchayat, stating that the petitioner as well as his elder son, Sairuddin, Sairuddin Ahmed, are both residents of Ward number 6 of the Bazana Pathar Gaon Panchayat, but they live in different houses, which is situated 3.5 kilometers apart since last 8 years. Next, madam. In order to show that the petitioner and his elder son live separately, the petitioner, by filing an additional affidavit, has relied on the uncertified copy of the electoral roll of Part 1, Fuhuratuli, Fuhuratoli, under 49 Sipajar LAC of the year 2025, where the house number of the petitioner is 372 and that of Sairuddin Ahmed, Sairuddin, is house number 513. Make it to 2025 as well as 2026. Note para. In view of above, referred. Certified copy of the voter electoral roll for the year 2025 and 2026. Showing the house of the petitioners and his elder sons to be separate. which is supported by the certificate issued by the Vice President of the concerned Gram Panchayat, stating that the houses of two persons are 3.5 kilometers apart. The court is of the considered opinion that the petitioner has been able to make out a case for interference with the ex parte opinion and grant the petitioner an opportunity to contest the proceedings. As the notice is not duly served in accordance with the provisions of three within of provisions of paragraph 3 within bracket 5 within bracket F. T5E and T5F. Of the foreigners within bracket travel, bracket was ordered from 1964. Next paragraph. Resulting from the said ex parte opinion is set aside and the matter is remanded back to the said learning tribunal for a fresh opinion after giving an opportunity to the petitioner to contest the proceedings. Next paragraph. The petitioner, namely so and so, who is duly represented by his learned counsel, is directed to appear before the learned member from a foreigners tribunal within bracket 4th at Darang at Mangalday. Honor before 28/9/2026, and by producing a certified copy of the order, he shall also file his written statement and produce all the documents on which he intends to rely. Thereafter, the learned tribunal shall provide reasonable time to the petitioner to produce his evidence and the witnesses, how to take steps for the appearance of the witnesses. Next, by the learned tribunal shall make an endeavor to conclude the proceedings as early as possible, giving in view the mandate of paragraph 3 within bracket 14 of the foreigners within bracket tribunals, it was ordered from 1964, as far as practicable. Next paragraph. The rate petition stands allowed to the extent as indicated above with an order of remand. Under the circumstances, there has been no orders to cost. Like the history written, written that the tribunals records expeditiously. Yes. Next.
My lord, well, may I take a lordship indulgence, my lord? Item 44. I have some problem because police is behind me. There was an order that after receiving TCR, bail may be considered. TCR has come.
We'll just see if the time permits. We'll take it up.
But your lordship is going at 1 p.m.
We have to, because there's a single bench of my esteemed brother.
If possible, kindly take before that. My lord, in item 35, lordship directed not to deport the proceeding, lordship. And lordship, if already not deported, deadline may be quoted, lordship.
Gotcha. That was item number
35.
35.
Yes, lord.
If not already deported. Item 35. If not already deported.
Connected.
Yes. Next.
Item 34.
She is the wife of the petitioner in item number 33. At the same address, the notice was served, but in this case, the process server's report at page 22 reflects that nobody could be found and it was hung at the panchayat office.
Panchayat office.
Lord.
I think that was. But it says they learned counsel for the petitioner and so and so for the respondents. Next, by filing this writ petition under Article 226 of the Constitution of India, the petitioner has still the impugned ex parte opinion dated page 14, dated 24/4/2019, passed by so and so. There are three references in case number so and so, FT case number so and so, reference case number so and so, by which the petitioner was declared to be a foreigner post 25/3/1971. Next, the learned standing counsel for the border and FT matters has opposed the prayer for interference with the impugned opinion on the ground of delay in latches in approaching this board. Next, the pursuant to the other past earlier, the records of the travel is received. To stop on a perusal of the records, it appears that that are not finding the petitioner at her place of residence, the notice of the proceedings was pasted in the
into her at the house and DDP secretary's signature was taken. But her signature is not.
I have,
You have this another process server report.
yes, at page
There are two
23.
services.
It's two something.
There's two services. On first date, you were found, you were given the notice. But there's no signature. Mr. Sharma,
Lordship.
look at this report. It's at back page of page 20. So that's
সমনত উল্লেখিত গাঁৱলৈ গৈ সমনত উল্লেখিত ব্যক্তিজনৰ বিষয়ে সোধ-পোছ কৰাত তেওঁ ঘৰত পাই নকল কপি দি দিন তাৰিখ সহ বুজাই দি ভিডিপি ছেক্ৰেটাৰী চহী লৈ মূল কপি মহামান্য আদালতলৈ প্ৰেৰণ কৰা হ'ল। But
Before this, in order, perfect, but the signature.
yes, Lordship, but signature is not here, Lordship. Yes, it's not here. The second time, Lordship.
As per the process service report, the notice was duly served. Mr. How, the signature of the petitioner does not appear in the process service report. Mr. Be that as it may, the notice was issued to the petitioner on the second occasion. And even on that, even on the date of service, the petitioner having not been found at a place of residence, the copy of the notice was hung at the office of the panchayat and the service report was returned. Next para, the manner of service of hanging the travelers notice at the panchayat office is not found to be in consonance with the procedure prescribed under paragraph 3 within bracket 5 within bracket F of the foreigners within bracket travelers bracket was order from 1964. Next paragraph, resultantly, the impugn opinion, ex parte opinion dated 24/4/2019 is found to be initiated. Next, accordingly, the ex parte opinion dated 24/4/2019 passed by so and so is hereby set aside. Next, the matter is remanded back to the said learned tribunal for a fresh decision. After giving an opportunity to the petitioner to contest the proceedings. Next, the petitioner, namely so and so, who is duly represented by her learned counsel, was directed to appear before the said learned tribunal on or before 28/9/2026. Around stop on the said date, the petitioner shall produce the certified copy of the order as well as file her written statement and also the documents on which she relies upon. Thereafter, the learned tribunal shall afford reasonable opportunity to the petitioner to produce his evidence, produce her evidence, and also to take steps by so required to, it should be so required for producing documents and witnesses. And the said learned tribunal shall hear and dispose of the matter, keeping in mind the mandate of paragraph 3 within bracket 14 of the foreigners within bracket travelers, which was order from 1964. As far as practicable. Next part. Reparation stands allowed to the extent as indicated above with order of remand. Next part, the circumstances, there should be no orders to cost. Next part, the travelers shall, the registry shall return the travelers records expeditiously.
Upgrade item 41.
Please allow footnote. Page 76 is the impugn order. In this case, my lord, the petitioner executed several documents before the concerned tribunal. Among the other documents, Exhibit F
is a list of Deputy Speaker of Assam Legislative Assembly of one late Amiruddin, alias Maulavi Muhammad Amiruddin, who happens to be the Deputy Speaker of Assam Legislative Assembly, the first, and he is the brother of his grandfather, the petitioner's grandfather's brother. That was wrongly observed and wrongly misconstrued. The learned member has said that he is the paternal uncle of the petitioner in the observation and finding. If I take your lordship to the next page, my lord. Page 78, my lord. Right. Yes, my lord. Lord, if I start from the beginning, Lord, the page 76, my lord. The last
The beginning will not permit you because then
Yes.
you'll have to wait for some other day.
Yes, my lord. Therefore, my lord, in short, if I submit before your lordship, my lord, very
How do
precise.
you link yourself to anyone whose presence is there in the country before 71?
Yes.
What is the document of your link?
Documents are, my lord, the voter list and the land documents. my lord. If I start from the voter list, my lord will kindly have a look at page 31, my lord. Page 31 is the voter list of his father pertaining to the year 1966. 32 is the vernacular, my lord. Abdul Mannaf, my lord. There are three names, my lord.
31.
Abdul Mannaf. Serial number 334, page 32, my lord. Annexure 3, my lord, of the writ petition. Thereafter, my lord, 70 is voter list at page 34, my lord. And the petitioner's voter list, my lord, at serial number, my lord.
Where is your written statement?
Yes, my lord. Start from page 55, my lord, lecture 11, my lord. There is an additional, my lord, written statement is also there, my lord. He was permitted to file my additional written statement also, my lord.
Here you have referred to a land document. Where is that?
My lord, there are several land documents which were exhibited, my lord. And among those land documents, my lord, I take your lordship to page 42, my lord. That is one of the land documents, my lord. There, my lord, will kindly have a look, my lord. Page 42, Muzaffar Hussain, he is my grandfather, my lord. Page 42, annexure 5, my lord. Now, my lord, in the next page, my lord, 43, my lord, if your lordship kindly turn to page 43, my lord. In 14th line, my lord, in the remarks. column.
Whatever is relevant to be read, you have, your photostat is so good that you can't read anything.
My lord, this is the certified copy, my lord, that I had obtained from the, my lord, concerned tribunal. This is how it was furnished to me, my lord.
And how will it help you if you can't read?
Yes, my lord, but At serial number, my lord, in page 43, my lord, if your lordship kindly have a look, my lord, let's see, my lord, 14th line, my lord. The
Please
name
read,
of,
because this is something I can't, at least I can't read.
my lord, will kindly come to page 43 for a moment. my
We're
lord.
there at page 43.
Yes, my lord. In 14th line, one Amiruddin, my lord, is there, my lord. And he is the first deputy speaker of the, my lord, Assam Legislative Assembly. And he is the brother of, my lord, the petitioner's grandfather, my lord, Muzaffar, my lord, Hussain. Amiruddin is there, my lord.
But if you can't read, you can't link.
Amiruddin can be read, my lord. Amiruddin is there.
Amiruddin is okay, but
Yes.
you see, we read
The whole line only, yes, I admit that.
we don't read in,
Yes, my lord. It is a very old document, my lord, in 1942, my lord, it was, this order was passed, my lord. 8/10/42, my lord. Page 45 reflects the name, my lord, together, my lord. Amiruddin is there, my lord, at serial number 1. There is a cut mark. Because he was no more. And at serial number 5, Muzaffar Hussain, my lord. Page 45. That is quite visible, my lord.
you see, when you show us the document, you have to show us that this, you see, this is a Jamadi of, let us say that this is a Jamadi of 50. This will be,
This is the Jamamandi of his, my lord, grandfather along with grandfather's other family members, my lord, including the brother of the grandfather, my lord, Amiruddin, my lord, who happened to be the, my lord, first deputy speaker of Assam Legislative Assembly, my lord.
this Jamadi would be sometime of 54, sorry, 466 Jamadi.
Yes.
How to link yourself to your projected grandfather?
We go to the other part, my lord. The virtue of voter list and other land documents also, my lord. Page 46 and 47, my lord, is the vernacular, my lord, of another, my lord, Jamamandi Kofi from same village, my lord. Muzaffar Hussein's name is there at serial number 1, page 47, my lord. And serial number 4, the left side, my lord, Abdul Mannas. Mannaf is there, my lord. Son of Muzaffar Hussain. This Mannaf is the father of the petitioner, my lord.
We'll deal with that land document.
The tribunal, if your lordship kindly turn to, my lord, the impugn order, my lord. The relevant, my lord, page for 78, my lord. Starts from 78. Tribunal has said that critical analysis of the reference. Exhibit A is the Jamamandi copy of Muzaffar, son of Sadir, which OP claims to be of his grandfather. The said document, according to OP, relates back to 1930-31. However, in absence of other subsequent documents relating to devolution of the said land document into the possession of OP's father or the to OP, the same could not be taken as a conclusive proof of having landed property of 1930 and 31. Exhibit B is another land document of OP's grandfather Muzaffar Hussain, as well as his grandpaternal uncle, but the said document, as is seen from the executive order, is of only 2010 onwards. Therefore, this particular document cannot be treated as a document for determining the citizenship. But linkage will be established, my lord, by virtue of that document also, my lord, from exhibit B, my lord. Another land document, exhibit C, my lord, of Mujafar Hussain, which Wafi asserts it to be of his grandfather for the period of 1966. However, the particular Jawabandi copy also suffers with some drawbacks as no subsequent land document has been produced, showing the said land document to have been devolved into possession of his father as inherited property. Further, as all these land document has not been proved by, as per procedure laid down by the Supreme Court, he has said. I just wanted to draw the linkage and lineage with my father and grandfather by virtue of this land document. And this is very clear. The name of the village remains same. There is no shifting. Nothing is there. Regarding this exhibit F, this is a list of Deputy Speaker of Assam Legislative Assembly of State Amiruddin, alias Maulavi Muhammad Amiruddin, which consists of 2 pages. Unfortunately, I could submit only 1 page before your lordship in this petition. And if your lordship kindly compare this list along with the land documents, this will be very clear, that this man is the paternal grandfather's brother of the petitioner. And that has been wrongly stated by the learned member of the tribunal, saying that I have claimed him to be one of my paternal uncle. This is also a wrong observation. He is the brother of the paternal grandfather. By virtue of land documents, that is also very clear.
No, the problem is that you don't derive your lineage from him. It has to be through your father.
My lord, the chain is there, my lord, the linkage is there, my lord.
What is your name?
I am, my lord, Abu Tahir, my lord. In fact, my lord, lordship allowed me, my lord, on 11th of my lord, June, my lord, 2025. Lordship permitted me to file an additional affidavit to bring on record, my lord, certain additional documents, which I have filed, my lord. There are some 2 documents I have, my lord, also annexed along with the petition. Lordship permitted me from running page 93, my lord, I filed additional affidavit, my lord. So the name of the petitioner, my lord, also appeared along with his mother and other family members. Page 95 and 96, running page of additional affidavit. The member of the tribunal has also said that I did not mention my mother's name, my lord, in the entire proceeding. Therefore, he had also one suspicion, my lord, regarding my linkage along with my mother.
Not there together.
Did not since
Because your family is not there together.
they're not there together. But I have, my lord, annexed the extracted voter list, my lord, with photograph, my lord, page 96, running page 96 of the additional affidavit, my lord. But you will kindly have a look, my lord, for a moment, my lord. Page 96, annexure A, my lord.
And your educational qualification does not match with the nature of lineage you are showing to us.
Not necessary, my lord, that everyone shall be having same,
We
my lord,
don't know
academic
this.
qualification, my lord.
We don't know, but that causes
There are
a.
many families, my lord, in many families.
We
my
don't
lord.
know, we can't generalize.
Yes, we can't
see a
generalize.
document and we are.
Somebody may be a non-matriculate, somebody may be a graduate, my lord. We can't say, my lord, some regarding the academic, my lord, qualification, who has studied up to what extent, my lord. That can't be said, my lord. It's a remote village, my lord. That is admitted, my lord. My lord will kindly come to page 96 for a moment, my lord. Here in this extracted voter list, my lord, along with the photograph, my lord, in the additional affidavit itself, my lord. Running page 96, my lord. 96, my lord.
No, that was not produced before the tribunal.
That was not produced, my lord, but lordship permitted me, my lord, to bring it on record.
Okay.
Yes, my lord. And for the interest of justice, my lord, I'm just trying to, my lord, produce before your lordship, my lord. This is along with the photograph, my lord, of the same person, my lord. The name of the petitioner is also there, my lord. The serial number 356, my lord, Abu Tahir, my lord. Last, my lord, in the middle row, my lord. Second last. In the middle row. Abu Tahir is the petitioner, and the left hand side, first column, my lord, and the last one, my lord, Jaleka Khatun. She is the mother of the petitioner. The concerned member, my lord, he had a doubt regarding, he had a suspicion that since the petitioner did not mention his mother's name, my lord, he could not draw a proper linkage along with his family members. My lord. This is a voter list of, my lord, pertaining to the year, my lord, 2021.
We are more or less in alignment with the opinion.
Yes,
The reason is, you see, assuming that the presentation you are making is correct,
my lord.
then even in your dream, you will not write a name which is not there in your, in the document you are showing to be the first deputy speaker of the state. His name was not Amiruddin. The document shows his, where did you show that some Maulavi so and so?
Yes, I mean,
So therefore, why would somebody write the name of a celebrity family member? Which delinks you from the said person.
my lord, in earlier days, my lord, if I may submit, if I may be permitted before your lordship, my lord.
No,
Somebody,
don't
my
say
lord, whose name is not there, my lord. In fact, my lord, if I,
don't
can
say
tell-
about those things because this is a proceeding of 2016.
yes, my lord,
You're not on old days. This is the present day.
yes. But the, my
Present
lord,
day you are
the list
presenting a
was,
document.
that list that was produced, my lord. Since 1937, page 48, lordship will kindly have a look on for a moment. This was the name of that Amiruddin, my lord, appeared, and he had served as a deputy speaker from the period of April 7, 1937 to 1946, my lord. Serial number 1, my lord.
We understand, but the name here is different. Maulavi Amiruddin.
That's what I'm trying to submit, my lord.
If that name was there, that means his voters list would also have same name. Because a man will not have a different name other than what is there in the voters list when he's a deputy speaker.
In fact, my lord, we have noticed in number of voter lists, my lord. Somebody, my lord, yesterday, when I remember, my lord, Sheikh was, my lord, added, my lord, along with the name, my lord. Just like that, my
This
lord.
matter. What happens in
Yes. My lord, regarding that aspect, my lord, the tribunal did not show any kind of doubt, my lord, and there was no rebuttal at all, my lord. Nothing was there, my lord.
even you
He
see,
is supposed to be the same person, my lord.
you see, even without an objection by Mr. Sharma, we are also taking an exception because this can't happen. If he's a member of the Legislative Assembly, his name has to be tracked down to a voters list. Well, this name has to be there.
My lord. In the land document, my lord, it is only mentioned as only Amiruddin, my lord, not Maulavi. Maulavi is not there, my lord. Sometimes we have seen, my lord, in number of cases, my lord. Somewhere, my lord, it is Sheikh, somewhere it is written as Sarkar, somewhere, my lord, Maulavi, my lord. Just like that, my lord. But the consistency is there, my lord. There is nothing as such, no discrepancy of, my lord, the original name, my lord. Nothing is there, my lord. Only the small V is added, my lord. But she will kindly consider that aspect, my lord. Otherwise, my lord, this man, my lord, is he has, my lord, in quite a, my lord, significant manner, my lord. He has established his chain and network along with this, and the, my lord, linkage and lineage along with all these persons, my lord. Not only by virtue of the land documents which he
You
exhibited.
already have bail.
My lord,
You already are on bail.
I'm already on bail.
Then why you are sitting on a hearing right now?
No, my lord, I'm leaving it to lordship, my lord. If necessary, my lord, lordship will kindly, my lord, proceed.
You are already on bail.
Yes.
Oh, start hearing the matter now. You made a claim for upleading. We thought that you are not on bail. Yes.
Then, my lord, lordship will be pleased to, my lord, post it on some other
You
day.
see, Mr. Mahmood is also.
Yes,
trying
yes,
to
I leave
uplead
it to
his
lordship,
for
my
bail,
lord.
but
My lord.
Mr. Merit was still not with you. You have not accepted any of the documents to be a document which clearly establishes your link. Take it up some other day. What says it? Sent it? This is matter for further consideration on. Give a date after 2 weeks.
My lord. Deep dive.
Very small matter, right? Yes. I can double for. Yes. That will do it. Small matter is something which you have never seen. Sitting here, where we had small matters, but.
Make and just say order dated 27/3/26. The last page may be seen.
Yes, we are not,
Yes.
we remember it.
Now, Lordship, so far my case is concerned, I have a good case. But today I will argue only for bail. I have adduced 6 witnesses. But the learned tribunal has discussed only a portion of the evidence of this proceeding. For a moment, kindly say, my lord, impugn order, it is page 46. Page 46. Operative portion may be seen, page 48. 48. Second para, the proceeding has submitted examination in chief of affidavit and filed 5 witnesses. Affidavit. The witnesses supporting the evidence of in chief of proceeding and exhibited as following documents. So these are the documents. Regarding document he has discussed, but regarding other witnesses except proceeding, to some extent, kindly see the last paragraph, page 48. Proceeding to the evidence, it is saying that proceeding through his evidence exhibited some documents which are as follows. So only the documents part which he said that has been discussed, but the other 5 witnesses who adduced in my favor, their evidences have not at all been discussed.
Where is your written statement?
Yes, 34.
Now you understand why there is no requirement of any discussion.
Hello?
Now, did you understand why there is no requirement of any discussion?
That I understand, but even then, in WS, this is very short and very carelessly written, I understood that. But even then, in the evidence part, why not we can see,
Mr. Mahmood,
page 36.
It is easy for you to say callous, but we find it a drafting of a learned counsel. We can't make that statement.
That's 36, in evidence, I have.
The senior government advocate, Mr. Sharma, would be very upset with us.
No, he will not upset because other witnesses' statements have not been discussed at all.
But what is it?
Of course.
There's no link, there's nothing has been shown.
No, I have, I
DW2
only read.
DW2 says that I am the aunt, and her link to the petition is not established.
No, linkage documents are sufficient here. Linkage documents.
No, Mr. Mahmood. We did not expect this from you. Page 34 is the written statement.
Yes,
Come to page 35.
That is-
But 35 says that my opposite party is born in India, brought up in India, his father's name appeared in so and so.
Yes.
That's all.
Yes.
Therefore, the
But in-
uncle,
I understand
sister,
that, I
brother,
understand.
nobody is there. The family is not there.
But exhibited documents, my lord, in the evidence, in page 36, you would say, in evidence, he has said a little more. For example, he has exhibited in the voter list of 1965.
You said that it's a very small matter. You give you two judgments immediately, where beyond pleading any evidence should not be developed.
So many documents. At this instance, my prayer is only that, it may be hard later on, because now police is behind me, kindly grant me bail. At least some documents, 65, 60, 70, which are the name in my father and grandfather, and my name is also there with my father, so these are things.
I think he is already protected, Lordship.
No,
No deportation is already there, Lordship.
no, no.
I
Don't
think
deport-
there is enough, Lordship.
No,
They
no.
will come from.
Is there?
Yes, Lordship.
No, not that. But if the traveler does not discuss five evidence, it has to be remanded back. We can't do anything. The traveler could have rejected it on the ground that there is no written statement cannot be corroborated.
Yes,
It could have been a three-line order, but it has to be referred to. You're sending it back. But Mr. Imru Mahmood, learned counsel for the petitioner and so for the respondents. Next, by filing this writ petition under Article 226 of the Constitution of India, the petitioner has said the opinion dated 18/7/2024, page 46, passed by so and so and so and so. By which the petitioner was declared to be a foreigner post 25 in 1971 stream. Next paragraph. In view of the order of demand, which the court proposes to pass, the court does not deem it a the court is not inclined to burden this order with the pleadings and the evidence of the witnesses on record. Next, it would suffice to mention that the learned standing counsel for the border and FT matters has opposed the writ petition on the ground of inordinate delay in selling the opinion dated 18/7/2024, as this writ petition was filed after 2 years on 19/3/2026. Moreover, it is submitted that the related statement is absolutely vague without any material particulars, and therefore there is no infirmity in the impugned opinion, as the entire evidence would be beyond pleadings. Next paragraph. On a perusal of the records, which of the tribunal, which was called for, It is noticed that the petitioner has examined six. Where's the record? Oh, acha, he's examined six witnesses, including petitioner himself, being Abdul Malik, ABDUL MALEK, petitioner within bracket PW1, sorry, OPW1. Next, comma, just give a comma, then go ahead. Jamila, JAMILA, Khatun, KHATUN, within bracket DW2, OPW2. Next is Malaysia, MALESHA, Malaysia Khatun, KHATUN, within bracket OPW3. Hatem Ali, HATEM, Hatem Ali. Within bracket OPW4. Kodam, KODM, Kodam Ali, from OPW5. And Ranjit Mia, within bracket OPW6. It would suffice to mention that it would be appropriate to mention that the record keeping of the learned travel is not appropriate as the evidence of the witnesses examined is not kept in serial order. Next one. In the imperial opinion dated 18/7/2024, although the learned tribunal has referred to the examination in chief by affidavit of the petitioner and 5 witnesses, there is no discussion of the evidence of any of the 6 witnesses. Most of the learned tribunal has only referred to the exhibited has only analyzed the exhibited documents. Full stop. Next one. The said procedure adopted by the learned tribunal of not discussing the 6 witnesses examined is not found to be in accordance with the procedural law, well settled procedural law. Full stop. The lack of discussion on the evidence of 6 witnesses examined and limiting the analysis only to the exhibited documents is found to have vitiated the impugned opinion. Accordingly, the court has no hesitation to set aside and set aside the impugned opinion dated so and so, passed by so and so and so and so, page 46. Resultantly, the matter stands remanded back to the said learned tribunal for a fresh decision. We passed on the basis of the materials and the pleadings and evidence already on record. Next paragraph. The petitioner, was duly represented by his learned counsel, is directed to appear before the said learned tribunal within the outer time limit of 28/9/2026. On the said date or on the on his appearance before the learned tribunal, the petitioner shall produce a certified copy of the order and await for further orders to be passed by the said learned tribunal. Next, the registry shall return back the tribunal's record expeditiously. Next, the court is further inclined to provide that on appearance of the petitioner, the petitioner shall also make a prayer for bail, which shall be considered by the said learned tribunal. So it is provided that the bail by the said learned tribunal shall be granted for a period of 30 days beyond the period of the fresh opinion to be passed by the said learned tribunal. Repressions shall allow the extended indicated above with an order of remand. So under the circumstances, there shall be no orders to cost. This is the same tribunal. Yes.
I shall take bail from there.
Yes, yes. It's an option open to you. If you want to take bail, you take bail, or if you don't want to take bail, you remove
That
that.
is lordships have suggested the order. Actually, there is no case at present.
If you don't want bail, we are ready to.
No, I am not on that. But when the order is set aside, is there any necessity of taking
It
bail?
is for you to decide. We said that if you don't want it, we will recall it.
No, definitely we will go. But my understanding on that,
No,
when the
we
order is.
respect it. That's why we are saying, if you don't want the bail condition, we are ready to do it.
Definitely, we will go.
You go, okay. What I said was duly understood by Mr. Sharma, by Mr. What do you call, both Mr. Sharma and the council along with them. They understood what transpired between us.
I have already asked to him, Doctor.
They are all aware. You are the one who is outdated.